On behalf of the Mackinac Center, I would like to welcome everyone to the Issues and Ideas Forum, Emergency Powers and Pandemic Mismanagement. On your table, you're going to see there are Q&A cards, and if you would like to ask our speakers some questions, I'm going to ask that you go ahead and fill them out and then hold them towards the end of the program, and we'll have someone come around and pick them up from you. So I'd like to introduce our speakers for the day. Daniel Dew directs Pacific Legal Foundation's legal policy efforts. The legal policy team works to expand individual liberty and human flourishing by leveraging PLF's legal expertise and strategic research into concrete legislative, administrative, and regulatory victories at the state and federal levels. He has led numerous successful public policy campaigns, including civil asset forfeiture reform, criminal justice reform, and removing government-imposed barriers to employment. Thank you for being here, Daniel. Michael Van Beek is a director of research for the Mackinac Center for Public Policy. He has offered several studies for the center, as well as analysis and commentaries that have been published in the Wall Street Journal, the Detroit News, the Detroit Free Press, the Grand Rapids Press, the Oakland Press, and elsewhere. Thank you. And we're going to go ahead and start with Michael with his presentation.
Thanks everyone for joining us this morning. It's great to be here. Great to see smiling faces, and thanks for your interest in this topic. It's a really important one in my view, and it's really relevant to, I think, many of the things that are still happening related to the pandemic. The Biden administration's vaccine mandate, that is issued through emergency authority, and many of the other policies that we're currently debating or being subjected to are still being issued under emergency authority. So figuring out what type of authority and emergency powers politicians and state officials and government officials should have is a really important issue that we need to think a lot about and get handled. What I want to talk about today first is the way that we should manage a pandemic, and this was this COVID-19 pandemic was, for most people, the very first one that they experienced on such a wide scale, such a broadly broadcast pandemic that influenced many people around the world. And so this was a new experience, and I think there are a lot of lessons that we can learn from the way that we managed this particular pandemic, and as we continue to continually manage it, or attempt to manage it. So what I want to talk about is rules for pandemic policies that we've learned over the course of this experience. And the first one, it sounds kind of silly to say that we should use the regular lawmaking process to make pandemic policies. Almost all of the policies that we had in Michigan related to minimizing the effect of the pandemic were not issued using the regular lawmaking process. They were issued by executive fiat, by executive order. These were not deliberated decisions. They did not go through the regular process for becoming law. They were simply issued by the executive office. Now, I will say there is a need for that kind of authority in government, but it should be restricted, and it should be limited to a certain time frame. So we can have both the executive authority and have a way to protect the regular lawmaking process and ensure separation of powers and all the other concerns that come with too much executive authority. The second lesson is that during a pandemic, we need to consider all public health concerns. For most of the COVID-19 pandemic, the government and public officials were focused almost exclusively on COVID-19. Now, it's a serious issue, no doubt, but there were all kinds of other public health concerns that we paid very little attention to, things like substance abuse, screenings, domestic abuse, mental health issues. These all sort of fell to the wayside. We need to keep in mind that a pandemic influences much more than just the disease that sparked it. And just now we are starting to learn of some of the ramifications of that laser-like focus that we spent on COVID-19. We need to make risk-based decisions as much as we can. And what I mean by that is what the government decides to do during a pandemic, the fine details of what the policy looks like, should be based on the risk that it poses to public health. Instead, what we got here in Michigan and in many other places I know is that we tried to split society into two groups, into the essential and the non-essential, and tried to limit movement based on that dichotomy. And that is part of what Friedrich Hayek would call the fatal conceit, the idea that administrators, government officials, people from on high could have enough information to make determinations about what things are essential for the public or for individuals and what things are non-essential. This just doesn't work. Countries have tried it in many different instances, and it just doesn't work. Life is just much more complicated than central planners, models, and textbooks tell them that it is. The fourth one is orders must be temporary. They must have an expiration date. If we are going to use executive orders, they have to declare exactly when they are going to expire. Still to this day in Michigan, we are getting orders from local public health officials and from state departments that do not have expiration dates. They are in effect until a government official says that they're no longer in effect. That's unacceptable, especially when you consider that some of these orders restrict basic constitutional rights that individuals have. Anything that restricts a basic right such as that should have a definitive expiration date. We also need to have a transparent decision-making process when we make pandemic policies. What we heard a lot during COVID-19 pandemic about the decisions were that they were based on science and data. That might be true, but that's not an explanation, and that's not a transparent decision-making process. A transparent process would do things like name the assumptions that are being used. It would admit the things that we do not know. It would admit the unknowns. It would identify potential negative downsides to the policy, and it would recognize alternatives to the policy. That's what transparent decision-making looks like, and we got almost none of that in this pandemic experience. We also need to provide notice to the public about new policies that are put in place. This happened very rarely in Michigan. My favorite example of how badly this can be done is in last July when Governor Whitmer made it mandatory under enforcement of law to wear a mask in public. She issued the order on a Friday at 9:30 in the morning, and it became effective immediately, which means that everyone who went to work that day without a mask on was technically a criminal and in violation of an executive order and could be fined or arrested. The public should have notice of when these things go into effect. It's just a basic, it's a basic decency provided to people, and it also will help encourage compliance. Because if you just slap on a executive order and a rule effective immediately, the compliance levels are going to be pretty pathetic. So giving people notice will give them ability to adjust and will actually increase the level of compliance with the order. We need also to have across-the-board consistency. What I mean by this is government agencies should be able to speak with one voice and have one policy or one message that they support consistently across the board. We didn't have this with COVID-19. There were times when Governor Whitmer, for instance, with youth sports, contact sports, for a while, Governor Whitmer decided that those shouldn't be allowed, and the Michigan Department of Health agreed and issued recommendations that said no one should play contact sports. And then the governor reversed course in a couple of weeks and said, no, it's okay, you can play contact sports now. This was right on before the football season began. And we knew they were playing football in Ohio, so people were really upset by the idea of Michigan kids not playing football while they're playing it in Ohio. So the governor changed course, but the health department didn't change their recommendations at all. So on one side, we had the state health department saying no one should play contact sports, it's too dangerous, and on the other hand, we had the governor saying no, it's okay. So we need to have consistency across the board. We should also default to voluntary compliance. There's kind of a dirty secret about COVID rules, and that is that they ultimately rely on voluntary compliance because ultimately they're not able to be enforced consistently across the board. We all know this. It's too difficult to, this is part of the fatal conceit that I mentioned earlier. The idea that law enforcement in Michigan could actually put these orders in place and enforce them across the board, across 10 million people, is ridiculous. And so we should recognize this fact and recognize the limit of government to enforce these and defer to voluntary compliance. Another way of thinking of it is the government should only issue orders that it is willing to thoroughly and completely enforce. That was not the case with COVID. The orders were issued, but there was very little attempt to actually enforce them. And then also we need to use a consistent source of information. With COVID-19, we had, the public had to, it was difficult to keep up with all the different orders and rules and mandates that were coming out of the state. Some came from the governor's office, some came from the state health department, some came from the occupational safety and health department, some came from the Department of Agriculture, some came from local health departments, some came from school districts. We should have consistent sources of these policies that are predictable and that people know where to look for these kinds of policies. Before I turn it over to Daniel, I want to also provide an update on some additional research that I've been doing along these lines related to emergency powers and other types of reforms that we might consider more generally about emergency powers themselves and not just about how to respond to a pandemic. So many of us were surprised when Governor Whitmer used emergency powers in response to the COVID-19 pandemic. She used a law that was on the books for 75 years. It hadn't been used in 50, and very little people knew that it was even there. But that's actually true for many more laws that are on the books right now in Michigan statute. There are dozens of emergency powers in statute that haven't been used before but are just laying around and could be used by state bureaucrats or state officials or local officials whenever they feel that they are necessary. So there's a lot of room for additional misuse of these powers unless we look at these statutes and get these emergency powers reformed. And it's not only at the state level, it's also at the local level as well. So cities have municipal codes and charters where they grant mayors emergency powers and city councils emergency powers to take actions that could suspend constitutional rights and limit the movement of people. In Michigan, some of them that I found that were kind of surprising were there's emergency powers from 1933 that gives the commissioner of the Department of Insurance in Michigan the ability to issue orders on banks if there's a financial crisis happening. It's still there. It's never been used that I've heard of, but it's just sitting on the books, waiting for a bureaucrat to decide that we're in a financial problem and we need to regulate the banks. There's emergency powers for adulterated products. So the governor can order any product to be banned if they feel that it is a danger to public health. or if it presents a threat to public safety, is what the statute says. There's emergency powers to deal with animals and animal diseases. So if there's animal diseases, the governor can issue an order and ban animals and from being used and from being transported around the state of Michigan as well. So there's a lot of work to do to improve Michigan law and statute, and we're just starting to scratch the surface, but we think that we can get these kinds of reforms done here in Michigan and improve both not the protection that individuals need to have from these kinds of emergency powers, but also improve the way that they are used when they are put into use. So thank you. I'll turn it over to Daniel.
All right. Well, thank you, Michael, and thank you, Mackinac, for having me, allowing me to speak. I'll just say I agree with everything that Michael said, except for I did have one question about something. As a native Ohioan, I thought it was always the case that we could play football in Ohio and you couldn't in Michigan. But I didn't know how I was going to get a Michigan joke in, but I'm glad you set me up like that. I appreciate that. So I'm with Pacific Legal Foundation. PLF is primarily a nonprofit litigation firm. We've been around for almost 50 years. We litigate in the areas of property rights, economic liberty, equality before the law, and separation of powers. So we sue the government a lot. Now, separation of powers doesn't usually get people really excited. It's not the sexiest topic. We talk about reg reform and making sure that each branch of government is performing its proper role. Usually the administrative state and the lack of separation of powers, it upends one person at a time or one business at a time, maybe an industry at one time. But the pandemic allowed us all collectively to have that same experience where the lack of separation of powers upended everybody at once. Now, so why is emergency powers, why is that an upend of the separation of powers? Well, the separation of powers ensures that the legislative branch makes the law, sets policy for the state, the executive branch executes those laws, and then the judiciary resolves conflicts or disputes by interpreting the laws. But during the last 20 months or so, that just hasn't been the case. We've had one person setting policy, deciding what is against the law at their whim. And so we've seen what it's like to live in a world without the separation of powers. Now, Justice Scalia used to always say that every president for life, every banana republic has a Bill of Rights. So what does he mean by that? You know, the First Amendment and Second Amendment, that gets so much attention. And he would even pull out the Russian Constitution and show their Bill of Rights, or even North Korea. North Korea's Bill of Rights, if you read it, it's pretty good. Some people would argue that it's better than ours. So what's the difference? The difference is that we have separation of powers. We have different branches of government competing with each other and keeping those checks on each other. So what did we see during the pandemic? We saw stay-at-home orders. At one point in 2020, 316 million Americans were told to stay at home unless it's for a government-authorized purpose. We had businesses closed down, many of them for good. We had, as Michael pointed out, we had government telling us which medical procedures we could receive. Schools were closed. My friend at Pegasus Institute liked to tell the story about how on Easter Sunday in 2020, that there were state troopers who were going by churches to take down license plates of people who were attending church services there. all of this because I'll just back up a little bit. Do you think that the legislator would have passed a law to allow that to happen? Certainly not. It was all decided by one person. And again, as Michael pointed out, we're not done, right? We've been in this for 20 months, and all of a sudden there's a new emergency order with the OSHA vaccine mandate. And we also have governors in other places using emergency powers on the other end, right? We have Texas where Governor Abbott issued an emergency order where private businesses can't require vaccination for their employees or people who enter. So it's not a partisan issue. And that's the next thing that I want to point out is that while this has turned into kind of a partisan issue, it shouldn't be. It should be the legislature inserting itself to reclaim its authority to make law. And I would argue that actually the lack of checks on emergency powers actually made the issue more partisan than it otherwise would have been. So what happened? So March 2020, COVID is coming. We don't know a whole lot about it, right? At that point, we thought, is it spread over services? Is it airborne? We don't know. We don't know anything. People were coming home from the grocery store and, Cloroxing their fruit before they would eat it. I mean, we just didn't know, right? And I think that perhaps at that time, that's when you want to use emergency authority. We didn't know. There wasn't time for the legislature to convene and to set policy for the state. So what would have happened had there been time limits on some of these emergency orders? If the legislature had to come in April or even May to take a vote and say, are we going to extend mask mandates? Are we going to keep schools closed? We don't know what would have happened because it didn't happen, right? So what happened is that legislators, they were kept out of the process and then were allowed to play Monday morning quarterback after the fact and heavily criticize the governors. And governors, I don't know if you guys know this in Michigan, but governors have big egos. And once they get entrenched in something, they don't like to change their mind. And so now it becomes a battle of, the more conservative legislatures who are criticizing everything that was ever done in relation to the pandemic versus, some who it feels like never ever want to leave this world of masks and social distancing and all the other government imposed restrictions because of COVID. So I'll talk about a couple of the states where reform has happened. So I'll talk a little bit about Ohio, my home state. Ohio is a supermajority Republican legislature and a Republican governor. At the beginning of the pandemic, they had this thing called, people were jokingly calling it wine with DeWine because we're all stuck at home, and at 2:00 every day he would have his press conference and he would announce to us what the government would allow us to do that day. So the legislature didn't like that, so they wanted to put restrictions on the governor's emergency powers. So they passed emergency powers reform. The governor vetoes it. They overrode the governor's veto, and they were able to do it. Governor DeWine threatened lawsuits, never did anything. He saw that it wasn't politically popular to override the legislature on this issue. So in that case, you have a Republican legislature restricting a governor of its own party. And then you've got Utah, which was in a similar situation where they have a supermajority Republican legislature. They have a Republican governor. And in that case, the previous governor, not the governor they have now, but he was issuing these emergency orders, and they already had a time restriction on the number of days that an emergency order could last. And so once the first order would expire, he would just issue the same thing over again. So he wouldn't have to worry about getting legislative approval. Now, in that case, when Utah passed their emergency powers reform, which requires legislative involvement in responses to emergencies, the governor actually signed the legislation, which was a welcome change from what we saw in Ohio and what we saw in other places. Now, it was overwhelmingly passed, and I don't know if Governor Cox was doing it out of a sense of separation of powers or because he knew it would get overridden, but I like to think that he did it because he wanted to do the right thing. And then finally, I'll talk about Kentucky. So Kentucky was the biggest mess of them all. So they have a super majority of Republicans in the legislature, and then they have Governor Andy Beshear, who is a Democrat and was especially heavy-handed. As I mentioned, he sent state troopers to churches to take down license plates on Easter Sunday, just crazy things like that. So the legislature comes in immediately in 2021, and the first thing they do is they pass restrictions on the governor's emergency powers. The legislature knew that he would veto whatever they sent him, and so they go out of session because they can only be in for a certain number of days, so they recess for a little bit. The governor waits the maximum number of days, vetoes. The legislature comes back immediately, overrides his veto, and so they think that they're in business. They've got these restrictions on the governor's emergency powers. And then the governor does something that I didn't even know was possible. I'm a lawyer, but it still baffles me how this even works. So the legislature overrode the governor's veto. The governor then files a lawsuit enjoining the legislature, who had already passed the law, enjoining the enactment of the law that they had overridden his veto on. It's procedurally, it's just really weird, right? Because it's the governor who's should be enforcing the laws. But anyway, he had a really friendly court. He picked his favorite judge, took it to that court. They gave him an injunction from the restrictions on his emergency powers from going into place. PLF, we found clients in another county in Kentucky. We filed a competing lawsuit, and we got an injunction from enforcement of the emergency orders. And so, you've got the conflict that you want. The Kentucky Supreme Court immediately takes this up so that they can hear it. We skipped the intermediate Court of Appeals. And eventually, after a long time, because the Kentucky Supreme Court didn't really want to rule on this, we won 7-0, upholding the restrictions on the governor's emergency powers in Kentucky. And so what we're seeing these fights. There's this real power grab, right? Whenever government sees another way that it can impose its rule, and in this case, they avoid the legislature completely, which is good for tyrannical governors, I guess, but bad for the rest of us. They're not going to let that go, right? And so one of the things that we've been looking at Pacific Legal Foundation is we've been looking at which may be dangerous, but we've been looking at the op-ed pages in the New York Times and other places like this. And what you see is this chorus of people calling. They're like, they say, this worked really great for COVID. It could work really great for other things: gun violence, climate change, homelessness, the differences in the way that people are treated based on race. all of these different areas. Now, these are very important policy areas that should be looked at by the legislature and debated and laws passed, but they're not emergencies, right? And that's part of the problem is trying to figure out the difference between a serious issue and what constitutes an emergency. And the reforms and restrictions that Michael had talked about, that we talk about at PLF, it will dissuade the abuse of these emergency powers. And so that's why it's so important that we stay on task and we always think about this in the long term and think about it structurally. And regardless of who is in power, regardless of whether we like or dislike what they're doing, if they are avoiding the structural separation of powers that is ingrained in our Constitution and our form of government, it needs to stop. It's not a referendum on any particular governor. It's not a referendum on pandemic management or anything like that. It is the core function of our government. It is the core protector of our individual liberties. Thank you.
Okay, if you have those question cards, if you want to hold them up, and Nathan and Ben will come by and pick them up. Oh, here we go. I'll bring this.
It's my questions that I have. Okay. If they give us the floor to ask questions, that would be great too. I don't know if they will do that or not.
Okay, I'm going to start with this one, and either one of you can answer or both of you can answer. If a law goes to legislature for vote based on citizens' petition, as it happened, with correct number of signatures, then is the result the legislature can change the wording of law before veto-proof vote?
Oh, yeah, in Michigan. Okay. Yep. Okay, so this is about the way that we reformed the emergency powers laws here. Okay, yeah. So just to, I mentioned briefly the law that Governor Whitmer had used to issue emergency orders in response to COVID-19. That was called the Emergency Powers of Governor Act, and it was enacted in 1945. And it has now been repealed from Michigan law, although the governor did not approve of it. She did not sign that law to repeal it. And the way that happened is there was a group called Unlock Michigan that led a citizen-led initiative where they got signatures of a couple 100,000 Michiganders for an initiative to repeal that law. And when the way that the Michigan Constitution works, or a particular feature of the Michigan Constitution is that when a citizen-led initiative like that gets enough signatures and is proposed, it goes to the legislature, and the legislature then decides whether or not that citizen-led initiative is going to go on the ballot for voters to vote on in the next election, or the legislature can approve of it with a majority vote, and then it becomes law and does not go to the governor's desk and does not need to get a signature from the governor. So Governor Whitmer did not get an opportunity to veto the repeal of the Emergency Powers of Governor Act in Michigan. So that was a very, from my perspective, a very good development, and it's an important safeguard now that we have, that law is no longer on the books. Interestingly enough, there is still another emergency powers law in Michigan statute. It's called the Emergency Management Act of 1976. And Governor Whitmer has not used that law since the older law has been repealed. I don't know why. but she has just decided not to issue or not to use that particular emergency law in response to the pandemic. She switched over to using different types of powers that are granted to the state health department director in a different set of statutes. So that is why many people were a bit confused when the Supreme Court ruled against the governor's use of emergency powers in a lawsuit that the Mackinac Center filed. And then nothing changed really, because the state health department then just turned around and issued basically identical orders that kept things like mask mandates and closed schools and closed restaurants and all those sorts of things, and other capacity limitations. So I hope that helps. As Daniel pointed out, these issues quickly become very complex and complicated, and legally operate in all these sorts of gray areas that we end up having to have these debates in the courts, because there's no clear process for how these things are supposed to work.
All right. Daniel, did you want to respond at all?
No, the Michigan process is pretty unique, and I like it, but it's pretty unique to Michigan.
Okay. Next question. The U.S. Supreme Court seemed reluctant to overturn the CDC's ban on tenant evictions. What can we expect from the conservatives as more cases involving government overreach come before the Supreme Court? Thank you.
Oh, I think that's a great question. So the CDC, so full disclosure, PLF filed one of the CDC cases. It's really interesting. So initially, the Supreme Court said, this is bad, but we're going to let you go until the time runs out. And then it came back, and it took it coming back for the Supreme Court to say that, tell the government that they can't do that anymore. I think that the justices are really looking at these things closer now. I remember one of the cases having to do with religion. Justice Gorsuch had a line in his opinion saying that maybe the Constitution took a vacation during the pandemic, but it can't become a sabbatical. And so I do think that there's going to be more scrutiny on these uses of emergency powers. I mean, at this point, it's just blatantly a way to do an end around of legislation. You know, you don't have the votes, you can't get it through Congress or a state legislature. Use emergency powers. Do it that way. I mean, look at the OSHA mandate. I mean, we're 20 months in. We've had a vaccine since the beginning of the year, and just now they're doing this emergency, using emergency powers to mandate vaccines. It's just absurd based on the timeline.
I'll just add to that, and I didn't go to law school, so if I'm getting out over my skis here, please or you can fact check me. The courts historically are hesitant and reluctant to overturn emergency orders from executives. And there's a good rationale for that. I mean, the justices on the courts they're not experts. They're not policy. I shouldn't say they're not experts. They are experts. They're legal experts, but they're not necessarily policy experts. And so they leave those decisions up to the executives. And the other thing that sort of stacks the deck against challenging these emergency powers legally is that they're often judged through a rational basis, which means as long as there's some authority somewhere that says that these kinds of policies are appropriate or needed, that's kind of all the bar you need to cross over in order to pass muster. So I think that's part of the issue too, and maybe that will change in the future, where courts are more interested and more willing to take on these kinds of challenges. But historically, they haven't been, and now we're just faced with an unprecedented use of emergency power and an unprecedented controversy about the use of emergency powers.
So I'll just add to that really quickly. Michael's exactly right. And what makes it even worse is that when these emergency orders do infringe on constitutional rights, usually if a law infringes on your constitutional rights, you get strict scrutiny review, meaning the government looks to see whether there's a compelling government interest and whether it's narrowly tailored, the law is narrowly tailored to serve that. But in an emergency, it seems like courts just go the opposite way. They say, well, it's an emergency, so we're not going to question it.
Yeah, yeah.
All right, thank you. The next one is two-part question. Where in the Michigan Constitution is the authority for the governor to issue emergency orders? And are Michigan laws on executive orders based on Michigan Constitution?
So I'll take a stab at that since it's very Michigan focused. So the governor has the police power through the Constitution, through the Michigan Constitution. So that is ultimately where the authority for emergency powers kind of is rooted. However, the emergency powers that the governor was using, they're not in the Constitution. Those are in state statute. So previous legislatures passed laws and previous governors signed laws that granted these kinds of powers to the governor that she could use during emergencies. Now, one of the things that Daniel mentioned that I think is really still a struggle to try to figure out exactly how to reform it well is the thing that triggers the use of these emergency powers. What is that? What is the threshold by which you can declare something meets the standard of emergency powers are needed now, and they're not needed in this other type of situation? The way the statutes that I've reviewed read is that it's very fuzzy. It's very unclear. They say things like, when public safety is threatened, or when there appears grave danger or a great crisis. These are all sort of subjective terms that are used, and so it's really up to the opinion of the executive to make that determination. And then when we have courts who won't sort of challenge that immediately or take that on. When we filed a lawsuit against the governor in May, and the Supreme Court didn't rule on it until October. Meanwhile, Michiganders' constitutional rights were suppressed and for that entire period. So yeah, it's largely a statutory issue, which is a good thing because we don't need to change the Michigan Constitution to reform it. However, I would offer that it might be a good idea to put into the Michigan Constitution some restrictions on the use of emergency powers so that future legislatures or future governors then can't sort of roll back types of reforms. And I believe that's what they did in Pennsylvania. Daniel might know more about that, but Pennsylvania made some really good reforms constitutionally that limit the use of emergency powers now in that state.
So two quick things. So first, in Kentucky, Governor Beshear tried to argue in his case that emergency powers were inherent in the office, and he lost on that 7-0. The Kentucky Supreme Court said any emergency powers that he has are grants from the legislature. As for Pennsylvania, they did put it in their constitution, and they did it for kind of an interesting reason. It's because the legislature could overturn or change an emergency order by resolution, but the problem is that under their constitution, resolutions had to be signed by the governor. And so, of course, the governor is never going to sign a resolution ending or changing his own emergency order. So they changed that in their constitution.
Okay.
All right, thank you. Now, a federal level question. If the federal government can mandate that employers enforce vaccination mandates on employees, what else can the government impose? For example, flu vaccinations, children COVID vaccinations, or even employee physicals that are given to the employer?
Right. Yes. No. That's a great point. And that's part of the problem is that not only is this an abuse of emergency power, it's also what authority does the federal government have to do this in any place? I don't know. I mean, that's the problem with the court's broad reading of the Commerce Clause, really. So it's an even bigger problem that that goes all the way back to the 1930s Supreme Court.
Right. Mike, anything to add on that?
No, I guess the only thing I would just want to highlight is how unprecedented this is. There is not, to my knowledge, any type of policy that is so that affects so many people that's ever been issued like this from OSHA, the federal department, and maybe not from the federal government. I mean, it's I guess the Affordable Care Act, Obamacare had a really large impact on a lot of people, but for many people who were already on health insurance plans, it really didn't make a big difference. But this has an impact on I don't know if anyone's done the counting actually on how many millions of people this affects, but just the width of or the depth of it, the impact of it is truly unprecedented.
Okay, now concerning executive orders, how can the governor expect citizens to follow executive orders if there is a low level of confidence in the executive orders?
Yeah, it's a great question, and I think part of what makes the issue of reforming emergency powers difficult is that, as Daniel pointed out, the way that it happened is it became really partisan, and the way and the use of emergency powers only fueled that partisanship. So when people talk about trying to reform these things, you're sort of assuming that you're opposed to all of the types of reform or the types of policies that the governor that the governor attempted. But I don't think that has to be the case. I think you still should be opposed to the way that they were used, the way that they functioned, and still be supportive potentially of the actions that the governor took. So part of reforming emergency powers laws is to make them more effective. So the way that they were used in this pandemic, they were done without warning. They were done for indefinite periods. They were complicated. They were complex. They were issued, for a while we had a new executive order coming out every day. It was like a full-time job just keeping up with all the changes, right? So all of those things led to low levels of compliance. So if you want higher levels of compliance and you want citizens to, change their behavior based on emergency orders, then you should go about issuing them in a different way, in a way that encourages more compliance than the sort of haphazard way that we experienced them this time.
All right, thank you. So mainstream always says about going with the science, but if you have natural antibodies to COVID and you're not allowed to do certain activities such as air travel, why can't something be done, or who is someone that's going to be able to do something about this due to the natural antibodies?
I'm not a doctor. I don't know. I can tell you if people want to restrict that kind of stuff, they should pass a law, but I don't know. Like, as far as the science goes, I'm not a scientist, so I can't really comment on that.
Well, I'll just say, related to the vaccines and the way natural immunity relates to that mandate, previous vaccine mandates that we have, or existing ones that we have for school children in particular, many of them take into consideration natural immunity. So if you are required, your child is required to get the chickenpox vaccine in order to enroll in school, but they don't have to get it if you can demonstrate that they've developed natural immunity to chickenpox. And that's true for some of the other vaccines that we mandate here in Michigan for school enrollment. And it's also worth noting that parents can opt out of those vaccines without any special reason. They can do it for medical reasons, obviously, if the vaccine is dangerous potentially to the child. They can do it for religious reasons, and they can do it just for philosophical reasons, which means you can just say, I'm opposed to this vaccine. I don't want my son to take it, or daughter. And it doesn't, you just have to sign a waiver, and then you are exempt. And there's no restrictions placed on your children. They don't have to wear masks, and they don't have to socially distance. They can just go to school. So what is happening with the OSHA vaccine mandate is really different in a lot of ways because it does not take into consideration natural immunity whatsoever, even though it's clear that it exists and it works. And in fact, a vaccine, all it does is trigger your natural immune system. So a vaccine really is just is part of natural immunity. It just triggers it. That's a fundamental difference with the vaccine mandate that we're facing from OSHA and other ones that we have in place, for instance, for school children.
All right, thank you. So we're down to our last few minutes here. If you had a question that wasn't answered, if Daniel and Mike, if you happen to have some time afterwards, if you're available to answer some questions, I would encourage you to ask them. And I'd like to really thank Daniel and Mike for their time today and their presentation. And thank you all for attending. On your way out, if you would like to visit, we have a publication table that has some of the other works done by the Mackinac Center. You can sign up for Capital Confidential, which is our news service. And everyone, thanks again and have a great day.